Here at Denton Peterson, we do a lot of work with respect to trade secrets. Trade secrets come up in employment actions a lot. They come up in relationships between independent contractors, and they come up in business relationships. And so we deal with them quite a bit. In Arizona, there's three factors that essentially decide whether something is a trade secret or not. First of all, it has to be secret, confidential. Second, it has to be valuable by virtue of being confidential. And third, it has to be subject to reasonable protections by the owner. So if you don't take care of it and keep it secret, then it's not going to be a trade secret under the law. Well, in 2016, the federal government passed the Defend Trade Secrets Act of 2016. It's a new federal cause of action, creates new opportunities for both employees and employers with respect to trade secrets, and it requires new provisions for employers who want to make sure that their employment contracts provide the maximum protection with respect to confidential information. So first, a little bit of background. The Defend Trade Secrets Act does not preempt state law. Arizona has state law about trade secrets. And specifically, it has the Uniform Trade Secrets Act, and that's been in place since 1990. That state law, although it's based upon a uniform law that a lot of other states have adopted, it's completely unique. So it's important to have someone who understands the nuances of Arizona's law with respect to trade secrets. Arizona's trade secret law that's existed since 1990 also preempts other common law causes of action. So it's important to understand the interplay between common law causes of action, contractual causes of action, and statutory causes of action like the Defend Trade Secrets Act. So again, it's important to talk to somebody who understands how all those laws work together to protect trade secrets and to make sure that people who own trade secrets have recourse if somebody's misappropriated them. One of the main provisions of this new Defend Trade Secrets Act of 2016 is that it has what's called an ex parte seizure right. Ex parte means you don't have to tell the other side. And a seizure right means you could go in and get the judge to grant the right to seize information or property to protect a trade secret. Now, it's not an easy thing to get. It never is an easy thing to get if you're not going to give notice to the other party. But it can apply if a few categories are met. First of all, if even an ordinary temporary restraining order is not going to be fast enough, if the defendant is likely to evade or not comply with a TRO, something like that. And if the defendant took a trade secret and the circumstances indicate that the defendant's likely to hide or destroy the secret information, if those things apply, then there's a chance that you might be able to get an ex parte seizure order under the new Defend Trade Secrets Act, the federal law. You got to be careful with it. A court can award damages, but the court can also, afterwards, if it decides that when you came in and got your ex parte seizure, that you overreached, that you took too much, that you exaggerated the trade secret, things like that, then the court has the right to award damages against the person who went in and got the seizure. It even can award punitives or attorney's fees in those situations. So it's important to consult with a lawyer who understands the Defend Trade Secrets Act before you go running off to court trying to get that exclusive kind of remedy.